United States, State of Florida, on the board.
Please be seated. We have a single case on the docket today. Nova Southeastern University against Yvette Majnerich, if I'm saying that correctly. Are counsel ready to proceed?
Yes, sir. May it please the court. My name is Bill Rogner. I represent the employer carrier in this case. I'd like to reserve 3 minutes of my time for rebuttal. Your Honors, prior to her 2002 work-related injury, the claimant below had a 13-year history of chronic respiratory problems and was always under the care of a physician. On April 29, 2002, she alleged that mold exposure at work aggravated those problems. That injury was accepted as compensable. In December 2004, the employer carrier denied further benefits, taking the position that the work-related injury was not the major contributing cause of the claimant's problems at that time. The case was tried on a number of issues. So
this is basically a CSE case?
Well, a couple of the issues are, but several of the issues are not CSE, Judge. And if I may, the first issue, the primary issue that we assert, or the primary error below, was in connection with a motion to deem compensability. And to be fair, this motion was filed and heard and ruled upon prior to this court's decision in Checkers, an en banc decision. The motion itself relied on two cases, Hutchinson and Collins. The motion cited those cases. Claimant's counsel argued those cases. The order, the merits order on appeal, relies on those two cases as well.
If that motion was granted in error, does it follow that you win on appeal?
We believe that's the case, Your Honor, and here's why. The judge below relied on those two cases, and if you read the judge's 4-page letter order, 2 full pages go to the deeming of compensability. And the judge's discussion of compensability makes it clear that the judge, pursuant to Hutchinson and Collins, confused the concepts of compensability and causation. Your Honor, in 1996, I came here and argued the Wayne Welling case, and Judge Fenton, you were on that panel, another en banc decision. And in that case, we were told that compensability means one thing and one thing only, whether an injury arose out of and in the course and scope of employment. Unfortunately, Hutchinson and Collins said the 120-day rule precluded challenges to both compensability and to causation, and that's the way this case was tried. Now, Your Honors, this court returned to the Welling decision in Checkers. Checkers had the same holding that Welling had, and that case was followed by Carlucci, Trimble, case you wrote, Judge Hawks, Mims, and most recently, Paisan, which is a case that Mr. McCabe and I came here and argued in November.
All right, so it boiled down, your contention is that there was not evidence of causation that would support the order.
That's not what I'm saying, Your Honor. What I'm saying is...
You would concede there is such evidence.
I would concede that there is evidence in this record that supports causation. But the judge did not apply the right legal analysis to this decision. And in Paisan, the case that was most recent, in that case, there was evidence about major contributing cause. In that case, the record had documents and deposition testimony that would support major contributing cause. But as in this case, the Paisan judge confused major contributing cause and compensability. And here's what the court said in Paisan. The claimant is entitled to benefits only so long as the industrial injury remains the major contributing cause of the disability. Checkers was not yet decided when the JCC issued this order. Its holding is applicable in this case, and its application might affect the JCC's ruling. And the case was remanded with instructions for the judge not to confuse compensability and causation. And that's exactly what happened in this case. The entire case...
But we know it would not affect the judge's ruling in this case because of the findings in paragraphs 31 and 32.
And I disagree with that, Judge, and here's why. If you look at the judge's letter order, her decision, 4 pages...
But certainly that is an inappropriate focus when we have the order that she eventually entered in much more detail.
Well, respectfully, Your Honor, what I would suggest to you is if you read her analysis, she says, and I quote, she says in that order, because the employer carrier waited until May of 2004 to question causation, it's too late. Okay? That's what she said. She said we were not permitted to challenge causation because that's what you told us in Hutchinson and Collins. And that's the exact analysis that this court told us in Checkers is incorrect.
Well, how do you get around paragraph 32 where the JCC accepts Dr. Robbins' opinion that on the work there that that doctor did, that the major contributing cause was the exposure at the building?
Your Honor, I concede that that is contained in that paragraph in the order. But if you look at the way this order is written, the merits order itself, not the letter, but the merits order itself, it's broken down into all these chapters. They, capitalize the title of each chapter as the judge goes through it. And Chapter 6, Findings of Fact and Conclusions of Law, begins with 4 pages of why the employer carrier is not allowed to challenge causation. 4 pages about the employer carrier cannot challenge causation because of the 120-day rule. That was wrong. It was incorrect. And we asked this court to reverse and allow the judge to apply the right legal analysis before reaching her conclusion.
Well, isn't 32 part of legal analysis? Why is that? Should we just ignore that?
No, Your Honor, I don't think you should ignore it. But the point is, she did not even meaningfully consider our major contributing cause defense because she told us both in the letter order and in the merits order that it was invalid as a matter of law. That was incorrect. Your Honors, if I may, the second issue on appeal, we assert that the JCC acted beyond her subject matter jurisdiction in ordering the employer carrier to reimburse a private health insurance provider that was not a party to this case. Now, Your Honors, legally there is no question the judge had no authority to do this. Claimant admits so in the answer brief. There are 4 appellate cases on point, all of which say my position is correct. They respond by saying we did not preserve the error below. First, we did preserve the error below because at page 2785 of the record, you will find a motion for rehearing, timely filed, that specifically and explicitly lays out the objection and the reasons for that objection. Moreover, this is a question of subject matter jurisdiction.
What's the remedy?
The remedy in this case is to reverse. There is no authority for a judge of compensation claims under any scenario to order an employer carrier to reimburse a private health insurance provider. Therefore, for this particular issue, there would be no reason to reverse and remand to ask the judge to do what she's powerless to do in the first place.
Should it just be ordered to be paid to the claimant?
No, Your Honor, that wasn't claimed. The correct remedy for this court is to simply reverse. That's a private contract matter between the claimant and her health insurance provider. Perhaps the health insurance provider might have a right of action for reimbursement. But the question before you is, did the judge of compensation claims have authority to do what she did? Now, in the other 4 cases, which I cite in the brief, the court doesn't reverse and remand with instructions to have the money paid to the claimant. That's not what happens because there's no guarantee that the claimant would reimburse the health insurance provider. It's pursuant to their contract. The other 4 cases that you've decided, it was simply reversed. In a lot of cases, there was a portion of the order affirmed. We affirm on this, we affirm on this. However, that portion of the order directing the employer carrier to reimburse a health insurance provider is reversed as a matter of law. And that's what we're asking you to do in this case.
All right, now, what about Grinnell's Park?
What about Reynolds Park?
Wasn't the award to the health insurer reversed and the matter remanded with directions that the money be awarded instead to the claimant, subject to a possible lien in favor of the health insurer?
Your Honor, I'll be honest with you. I was not aware of that part of the Reynolds case, and I apologize for that. But and I'd have to see the facts. And I don't know if in that case the claimant had actually paid it out of her pocket. I have no idea. All I know is this court has told us that a judge of compensation claims has no jurisdiction to address this issue, and she should not address it.
What about Sarasota County School Board against Castagna?
I'm not familiar with that case, Judge.
Let me read the sentence to you. Although the JCC is without jurisdiction to order the employer servicing agent to reimburse a third-party insurer who is not before the JCC should award to claimant all the medical benefits due, and she shall ensure that those entities, the health insurers, are properly reimbursed.
Well, Your Honor, my suggestion would be at the very least you reverse and remand. We submit that the judge committed legal error and the order should be reversed. Claimant's counsel comes close to conceding in the answer brief that the order should be reversed, and we're asking you to do that. Your Honors, with regard to the third issue, it addresses this phantom benefit, something called a prescription account. And Judge Benton, you asked about CSE. This is a CSE issue. This prescription account is not described anywhere in the record. It's not recommended by any physician or discussed by any physician in this 3,000-page transcript. I've defended these cases for 17 years. I have no idea what this thing is. We assert that absent a description of what it is and absent testimony that it's causally related, medically necessary, and reasonable, that the judge did not have the authority to grant the request. Now, again... Okay,
can that be read as simply requiring the employer to pay for pharmacy, pay pharmacy bills that the claimant is incurring?
No, sir. It can't be read that way. Now, assuming you affirm the decision below with regard to the causation issue, that would be our obligation. In fact, the statute gives the claimant the full, fair, and free right of selection of any pharmacy she wants. But the way it has to work, the way it does work, is the following. The doctor writes a prescription. The claimant takes a prescription to the pharmacy. The pharmacy fills the prescription and bills the carrier. Pursuant to the fee schedule, the carrier pays a scheduled amount. They have 45 days to pay the bill following receipt on the proper form. That's the way it works. There is no authority in the workers' compensation law for either prepayment for any service or for some kind of specialized account that would give the claimant a card or something that would allow her to simply go fill prescriptions. There's no authority for this. There's certainly no evidence that would justify the award of a prescription.
But does the order require prepayment?
The order requires us to set up something that we don't even know what it is, which is a prescription account. We don't know how to do that. No doctor recommended it. No doctor discussed it. There's no prescription for it. There's no expert testimony regarding its need.
Was there a problem in her getting the pharmaceuticals that were prescribed?
The record reflects that she testified that there was a problem getting her prescriptions filled, and the remedy is to go to the judge and have the judge order them to fill the prescriptions. It's not to set up some kind of specialized account.
To order the pharmacy?
No. Order the employer carrier.
Isn't that all that's happening here?
No, Judge. That's not all that's happening. We've been told to set up a specialized account. And if this isn't reversed, we'll be subject to a Rule Nisi proceeding requiring us to set up something that we don't know how to do. We don't know that there's any such thing as a prescription account. It was made up by the claimant's lawyer at trial. There's no record evidence at all addressing it. Your Honors, I see my time is just about up. I'll reserve what I have left for rebuttal.
May it please the Court, my name is Bill McCabe. I represent the claimant, Yvette Majnerich. Now, of course, we submit that the judge has probably granted the claimant's motion to deem compensability, but beyond that, I mean, if there's some error there, it's harmless error because, as the Court's already noted, this judge made specific findings that the major contributing cause of the claimant's condition was her exposure at work. And the Court's already zeroed in on the paragraphs. There's paragraph 31 and 32 of the order, where the judge accepts the opinions of Dr. Robbins, who's a board-certified occupational environmental specialist. I accept further Dr. Robbins' opinions that the claimant developed an autoimmune disease as a result of her lasting exposure to mold at work. Paragraph 32, he accepts it. I mean, so even if there was error in granting the claimant's motion to deem compensability, the judge has already accepted Dr. Robbins' opinion concerning causation. The same thing with the psychiatric condition. The judge on paragraph 42 accepted Dr. Magid over that of Dr. Miller concerning the major contributing cause of claimant's depression. So it seems like it's harmless error if there is error at all. Also point out that the carrier in this case put down in the original May 24th, 2004 pretrial stipulation that the conditions were accepted as compensable. It wasn't until March 2nd, 2005, which was 14 days before the original 3/16/05 final hearing, that they amended the pretrial stipulation to claim that the condition was no longer related. However, getting to the issue that they have raised on appeal, the judge did not commit reversible error. In fact, the judge properly found the condition to be compensable. 440.24 is the statute that states that if the employer carrier does not deny the compensability of a condition within 120 days after the initial provision of benefits, then the condition is deemed compensable. I mean, that's what it amounts to. The purpose of it, this court discussed the purpose of it in Solsa versus Werner Enterprises. It's to ensure that the employer carrier complies with the mandate of the section to immediately and in good faith commence investigation of the employee's entitlement to benefits. It works to fulfill the legislative goal of speedy resolution of claims and protects the claimant from prolonged periods of uncertainty regarding the employer carrier's position on the claim's compensability. In this case, they began providing benefits to this claimant. The judge found it was October 11th, 2002, when Dr. David began treating claimant as an authorized physician. Actually, they provided benefits before that. They started paying TTD benefits effective July 29th, 2002.
All right, but how long was this lady at Nova University?
How long did she work there?
Right.
Well, she worked there since 1999. Or excuse me, 1989. She went to college there, she worked part-time, then when she graduated, she became a full-time employee. I'm sorry, I think it was 1991. The exposures that she talked about were in the Parker building, which occurred, I guess she's alleged mold and everything between January 2002 and actually July 2002.
So a 6-month period.
Yes, sir.
And she had allergies before that.
She had allergies before that. She would take medication, and then she said she would just have occasional drippy sinus or whatever. The last time she saw Dr. Greenstein before her exposure condition, I believe, was in the year 2000. He was the doctor that was treating her beforehand. Here's the way...
And there seemed to be almost a consensus that a couple of courses of antibiotics should clear everything up. And then we're talking about another several years afterwards, during which she spent 95% of her time at home.
Well, if we're talking about causation, again, Dr. Robbins opined that it was causally related to her exposure at work. The judge accepted that opinion, and they haven't appealed it. But getting to the 440.20, I'm sorry.
Well, just so I mean, that I haven't heard them complain either that there's not evidentiary support for her findings in paragraphs 31, 32, 42. And it does seem like it's hard to understand why they're so interested in focusing on the grant of the motion, since they don't seem to be in better shape, even if that is disregarded. Well, let me ask you this. Was Robbins, he was never authorized, right?
He was the claimant's IME. And he was an environmental doctor who Dr. David recommended on October 11, 2002 that the claimant see such a doctor. The carrier never authorized such a doctor. They gave a couple of names, but they were not that type of health care provider. But again, there's nothing on this appeal that challenges the acceptance of Dr. Robbins' opinions or whether his opinion should have even been admitted or anything like that. None of that's in here. None of that's in here.
Mr. McCabe, if the judge is operating under a misconception of what is still at issue, in other words, she spends all this time saying that causation is now not available for dispute. It wasn't a clear alternative finding, was it? I mean, she didn't have an introductory paragraph to 31 or 32 that said, even in spite of the 120-day rule, if that didn't exist, then I would make the following findings. There's no indication that she ever understood the correct burden or the correct issues before her, is there?
Well, she doesn't divide it up like that, but she clearly accepts his opinion. I mean, I don't know. I mean, this is crystal clear. And crystal clear accepts the...
Well, judges sometimes do make alternative rulings, correct?
Which is what...
I rule for you this way, and then also, even if that didn't exist, I would also make a ruling under this ground so that the court would clearly know that there was not a misperception or conception of what the burden was.
Well, sometimes they say that, yes, and this one she didn't, but it's clear that she still accepted his opinion. I'd like to talk about the 440-24 too for just a minute, because here's what the whole thing boils down to as I see it. The statute says if you pay for a benefit, you don't deny it within 120 days, and you've accepted that condition, you can still challenge entitlement to benefits later. So the issue seems to be, what condition is deemed compensable? That seems to really be the issue. My position is, and I think the cases support it, it's the condition that the carrier was providing treatment for. That's deemed compensable.
All right. And another way to maybe come at this is, what did they have at the hearing that the employer did not have at its disposal before the 120 days ran?
Nothing. They had, well, let's put it this way.
They had their IME, right?
They had their IME, Judge, but on August 26, 2002, the same date that the notice of injury was received by the carrier, they sent out a 120-day letter. The claimant saw 6 doctors, 6 different doctors within 120 days of that 8/26/02 letter. One of the doctors, Dr. Rosenblum, I think it was, who she saw in November, said it was a temporary aggravation. They had plenty of time. They didn't do anything as far as controverting or clarifying what they were treating. They sent out another 120-day letter in September of 2003. Didn't do anything. They didn't even ask Dr. David, who was the authorized treating physician, about compensability until a fax was sent in May of 2004. Now, the Clements versus Walt Disney World case, I like that case because in that case the carrier specifically accepted exacerbation of a pre-existing condition. And this court referred to that also in another case, the Mims case, which just came out recently. It's cited in the briefs. If a carrier wants to claim that we're only accepting the exacerbation or aggravation of a pre-existing condition, then say so. They got 120 days to figure it out. They can't come back, 2.5, 3 years later and say, oh, we were only paying for a temporary aggravation of a pre-existing condition. They paid this lady TTD for 2 years. They started paying her permanent impairment benefits.
Well, the statute never uses the word condition, correct?
It doesn't use the word condition. It says compensability of the, I don't have it right in front of me, compensability of the claim or something like that, entitlement to benefits. And this court, for example, in the Checkers case, it says that sometimes decisions have blurred the distinction between compensability and entitlement to benefits. And then and incidentally, Checkers is a case where they found that the claimant reached MMI with a 0% permanent impairment rating for the compensable accident. That's not the situation here. Here the claimant has a 27% impairment rating. Then in Citrus County School Board v. Carlucci, it says Section 440-24 does not preclude the E/C from challenging claimant's entitlement to benefits by contending that the injuries resulting from the industrial accident were not the major contributing cause of the claimant's need for further treatment or surgery. Okay, what are the injuries resulting from the compensable accident? Aren't they, per 440-24, the injuries that the employer carrier has accepted as compensable by providing benefits for them for 2.5 years?
Well, doesn't Checkers really say that what is being admitted to, or that you lose the ability to deny compensability of, is that there was an accident that happened and some injury resulted? So if, in fact, she had a previous existing condition that was aggravated, then the only thing that they would be prohibited from challenging is that it was aggregate. I mean, it's not everything, right?
Well, if they can come back in 2.5 years after they've provided treatment for this claimant's upper respiratory condition and chemical sensitivity and all those things that the doctors testified to, and claim it was just a little temporary exacerbation that should have been over in 2 or 3 months like the adjuster stated in her deposition, then I submit that 44024 has no purpose.
Well, didn't the JCC really almost have a responsibility to address it at 2 different times? I mean, it seems like initially, the initial determination of whether it's compensable or not, you have a situation of, okay, did her allergies really cause her current conditions, or was it a result of the mold problem in the building? So you have almost an initial determination, but then the carrier also gets to come in later and say, well, she may have had that then, but even if she had that then, it's no longer the cause of what her problems are now, right? Isn't that where we're at in Checkers?
And in order for them to do that, would they not need to have some testimony from somebody saying that the condition that this lady has today is different than the condition that we treated her for 2.5 years?
So what I'm suggesting is, wouldn't it be appropriate, or is it appropriate, for the JCC to address both the 120-day rule on the initial point in time, but to also have some major contributing cause finding addressing something that's down the road? Is that the way this is supposed to work under Checkers or not?
I think it could work that way, yes, but the judge here has found that the condition that the employer carrier has treated the claimant for 2.5 years and paid temporary total disability benefits, provided medical treatment, and paid permanent impairment benefits on is deemed compensable. There's no evidence in this record that the condition now is any different than this condition that was deemed compensable. The judge in this case does go further and does say, I accept Dr. Robbins' opinions. I accept Dr. Majid's opinions, which was a psychiatrist.
Yeah, what I'm trying to offer is maybe a reason why the JCC did it the way it was done.
That's possible. That's possible.
Can you help us with this question about reimbursing the health insurer?
Well, the objection that I had on that one is they never raised any kind of defenses to that at the hearing. They did file a motion for rehearing, and I don't really think it's jurisdictional. I mean, the cases, I agree, state that the judge errs if he directs the employer carrier to pay directly to a third health care provider. Cases do say that. But the carrier still owes it. And I guess one option is to pay the claimant and have the claimant pay it. But the carrier is supposed to pay for reasonable medical treatment that a claimant receives, and in this case they didn't. The claimant was fortunate that there was a health care provider that picked it up.
Now, you stated that very broadly. You say it was error even to make the awards to the health care providers. Is that right? In other words, it's $75 to this doctor and...
Oh, I'm sorry. No, I may have said that, but I didn't mean that. I meant to third-party health insurance company. I beg your pardon on that one. No, the health care providers absolutely pay directly to them.
All right, so why shouldn't the motion for rehearing, wasn't that enough to preserve the issue?
Because they never raised it as a defense in the first place. Aren't you supposed to, I mean, it's not like coming up with a defense at the end. I don't know, seems to me. I'd like to just really touch the prescription. I guess I'm running out of time, but it's common. I don't know what the deal is on that. The claimant goes to a drugstore to get their prescriptions. If I knock this off again. The claimant goes to a drugstore to get prescriptions. All it is set up an account at the local Walgreens or wherever the claimant wants to go to get her prescriptions filled. That's all. It's no big deal.
Where is the statutory authority for that?
Well, the statutory authority is, I cite the statute in my brief where the claimant can select whatever pharmacist they want.
Right, but that doesn't mean that they have to set up an account with that pharmacy ahead of time, does it?
Well, you're trying to get benefits to an injured worker quickly and efficiently. The easiest way, and it happens in the field, I don't know, I'm kind of confused. It happens in the field where the claimant says, I live near this Walgreens. This is where I'm going to get my prescriptions. And then the claimant walks in with a prescription from their authorized doctor, right, to that pharmacist who's already familiar with the insurance company, already knows who the adjuster is, already knows what claim forms to send in.
But this order isn't necessary for this claimant to be able to do that exact same thing, is it? that setting up this account isn't necessary for the claimant to be able to get a prescription from her doctor and walk in and get it filled, right?
Well, the judge found that the claimant was having difficulty getting her prescriptions, and so directed them to set up an account with a pharmacist. And again, on this point, I know I've exceeded my time, but again, on this point, the carrier made no defense to this claim. It was in the pretrial stipulation.
Well, I mean, clearly they don't have to sit and list all the things that the JCC can never do and say, Judge, don't ever do these things that you clearly can't do. I mean, imposing sanctions, for instance, that you have no authority to impose, or deciding that there's a more efficient way to provide benefits than the legislature has selected in the statute. I mean...
But this was not even mentioned in the motion for rehearing, right?
No, it was not, Your Honor. It was not. Thank you.
Thank you, Mr. McCabe.
May it please the Court. Your Honors, Mr. McCabe, in his discussion of the deeming compensability issue, stood here and argued Hutchinson and Collins again, that the condition is what you are defaulted under on the 120-day rule, and that is not correct. The only thing we can't say is that for some period of time, whether it was a week or a year, her condition didn't get worse. We're stuck, okay? But take a back injury. You're in pain, you have a work-related injury, it gets worse, more treatment, more pain, it goes back to baseline, you're done.
What evidence did you offer that her condition differed at the time of the hearing from what it was earlier on when you accepted it as compensable?
We offered the opinions of Dr. David, for example, who said that her condition in 2005 was no longer related to the work-related exposure. I mean, this is a medical question. It's a causation question, and we are sort of having the same debate that was had with the judge in this case, where the judge says 120-day rule precludes causation challenges. It doesn't. Checkers says it doesn't. Trimble says it doesn't. Carlucci says it doesn't. Mims says it doesn't. We're allowed to challenge causation, and the judge said we couldn't.
Dr. David did not testify that her exposure was the major contributing cause.
No, Dr. David was our primary doctor.
I understand.
It was our primary witness, and Dr. David is the one that they used to establish that her condition in 2005 was not related to the condition or to the aggravation that occurred in 2002.
You're sure about that?
I'm certain about it, Judge.
Your IME was no help, right?
The IME, I believe it was a help, Your Honor, but this isn't really the issue to me. And I'm asserting that our issue, Judge, is that the judge below precluded us from even having this discussion.
There was evidence you offered that was excluded.
No, Your Honor. But the judge said in her letter order, and she said in the merits order, that the employer carrier can't challenge causation anymore because of the 120-day rule. That's error. And that's our position in this case, Your Honor.
And what do you say to the counter-argument that if error, it was harmless?
Because, Your Honor, as was recognized in Paisan, exact same type of facts, exact same type of order, the court said in that case, it's apparent that the judge's reasoning was clouded by this improper reliance on two cases from which the court has receded. We respectfully request that you ask the judge to consider the case in light of the Checkers decision. And I'm out of time unless you have other questions.
With the prescription account issue, how was it preserved?
How was it preserved? In the pretrial, Your Honor, there were 21 medical claims raised, including this claim for a prescription account. The employer carrier defended the case in two ways in the pretrial. One, by indicating that none of the claimed 21 medical benefits were reasonable or medically necessary. And then subsequently, in a pretrial amendment, filed timely, conceded by the other side, that the major contributing cause of the claimant's need for all of those medical benefits was not the work-related injury. We assert that that alone preserves the error. What they've suggested, Your Honor, is that we should have raised an affirmative defense to the award of the prescription account. And what we're suggesting to you is that they did not establish even a prima facie case for the award of the account where there's no testimony describing it or indicating that it's causally related, medically necessary, or reasonable. Thank you.
Thank you, Mr. Rogan. Court is in recess.